view in the matter of Saipem S.P.A. and others and Petrofac Ltd. and another.
Yes, good morning, Mr. Johnson.
My Lord, thank you. We've made real progress with agreeing a document overnight. We're not quite there, but I would hope that by the time I've finished ground one of the introductory points on ground two, we may be there.
Well, we have an afternoon to read in any event, but
I just heard from the left it is agreed, so we will be able to get there.
even better.
If I may then turn to ground one of the appeal. Ground one of the appeal, of course, concerns the appellant's contention that the plan fails the no worse off test. Maybe 2 points of common ground to note before we get into the detail of the argument. The first point of common ground is the content of the relevant alternative. The judge found that it was a group-wide liquidation following hearing oral evidence from Mr. Sousa, the group CFO, and Mr. Bennett, the independent expert from Teneo, and Mr. Reed, a representative of the AHG. There has been no appeal against that decision. So that is 1 point of common background to the no worse off test. The second point of common background is what would happen to the appellant's claims as creditors under the plans, the claims they assert against the companies as creditors in terms of pounds and pence dividend within the group-wide liquidation. Again, there it's common ground that the returns given to them under the plan beat the returns that they would get under a group-wide liquidation. So we say 2 important framing points to consider before we look at the legal question that faces the court. So against the backdrop of those 2 common points, where do the appellants go? They say that if the plan companies collapse into liquidation, the appellants will have a competitive advantage when bidding for contracts in the market because we will have exited the market, and that will give rise to future increased profits for them on those contracts. And the appellant's stated case before the court in their submissions and evidence is that the court has no jurisdiction to approve these plans unless the appellants are given an extra $340 million. That is what they say they have by way of additional claim as a competitor in respect of the additional contracts. Now, as the court knows, we do not agree that figure, and I'll come on to that a little later at the end of my submissions on ground one. But I think it is worth stepping back and understanding the consequence of the position of the appellants. They are saying to this court that the plans are jurisdictionally flawed unless they get an extra $340 million in circumstances where it's common ground that they are unsecured creditors who would rank behind $600 million worth of unpaid secured debt within the liquidations. We say the judge was right to reject their argument that these benefits should be taken into account within the test. We essentially say there are 4 particular points as to why he was right that we would propose to develop orally subject to the court. First, we say the appellants are wrong as a matter of statutory construction. Second, we say their case is inconsistent with the reasoning in the case law, primarily in the context of plans as already decided, but also back in the context of schemes which we do say is relevant. Third, their argument runs contrary to the policy of Part 26A and the rescue culture. And fourth, we say it could not have been intended by Parliament when enacting Part 26A that this hard jurisdictional test would have the consequences that the appellant's argument entails.
Well, your 4th point is just a facet of your 1st point. You don't construe the words of a statute in a vacuum. You construe them by reference to the parliamentary intention. So your fourth and your first points are, or should be, one and the same.
My lord is quite correct. I can move it up. I was going to do the consequences of the construction at the same time as policy, but I can move them up the batting order. We'll cover the ground along the way. First then, can we go straight to the provision, which is in the authorities bundle, tab 26, page 887. So 901G, as the court knows, identifies when the section applies. We can start with condition 901G3, which contains condition A, the no worse off test. And we do say first it's important to put it in its proper context. That is that it's a jurisdictional gateway through which a plan company must pass before the court even has the power to sanction a plan by exercising its cross-class cram-down power. And we therefore say that it does a sensible task in ensuring that plans will be rejected as jurisdictionally unacceptable because they do not meet a minimum threshold requirement. Now, the judge relied on that to say that it makes perfect sense for the test to be as clear-cut and as binary as possible. That's paragraph 70 sub 2 of the judgment, and we say he was right to make that finding. Within the same subparagraph, he said that the jurisdictional gateway should not require a roving inquiry into the individual circumstances of each member of the class to identify whether they're worse off in some broad or general sense. And we again say that he was right to make that finding.
Are you going to tell us why you think he was right?
My lord, absolutely. And the starting point for that is paragraph 14 of our skeleton argument, which is core bundle, tab 5, page 57.
The point you have to meet, I think, on this is that this is not a test which is to be applied at an earlier stage in the process. For example, at the time at which meetings are convened, for example, where you do need a sort of fairly hard line test because you're determining class, for example, or you're determining whether to hold a meeting. This, it is said, is by definition something that will be looked at sanction, where on any view the court can look broadly and should be looking broadly at all the circumstances when exercising its discretion.
And we don't dissent from the point my lord just made that when exercising discretion the court has a broad remit. And as the cases have made clear, the satisfactions of the conditions within 901G do not mean that it necessarily follows that a court will sanction a plan. The court still retains a general discretion to say no. And we say what one shouldn't do, and what the appellant's argument does, is conflates the quay competitor position in its role within the statutory framework. And we say to the extent that it's relevant only within the general discretionary sense rather than the no worse off sense. Just focusing, if I may, on the wording of the test in 901G3. The question is whether none of the members of the dissenting class would be any worse off under the plan than they would be in the relevant alternative. So that's the focus of the test. What does dissenting class mean in that context? We know that from 90G sub 1, 901G sub 1, that defines the dissenting class as being a class of creditors, or as the case may be, a class of members of the company who have said no. So it defines your dissenting class as a class of creditors. So taken together, what the question for the court is, that none of the creditors would be worse off than in the relevant alternative. That's the question that's being posed by section 901G.
Or it could be, and just to be clear, it could be that none of the members are worse off either.
Oh, well, of course, absolutely. If one is seeking to cram down a dissenting class of members, absolutely. I completely agree with that. Because the dissenting class is defined by reference to that you could have a creditors class or a member class.
Yeah.
So we say the first point of the analysis is to consider what is meant by the word creditors in the context of this scheme, or members in the context of another, when seen in its proper statutory context. And we say that both creditors and members are defined by reference to their rights as against the company. And focusing on creditor as we have in this case, because we are concerned with creditors. Within our skeleton argument, we cite a number of authorities for the proposition that when one is proposing a scheme, and we say necessarily a plan, the only relationship that you can impact under that framework without the consent of the creditor is their rights in their capacity as creditor of the company. And that's paragraph 14.4 to 14.6 of our skeleton, CV5, tab 58.
So which paragraph again?
My lord, I'm so sorry. Paragraph 14, subparagraph 4 through to subparagraph 6.
You can require creditors under a scheme or a plan to waive their rights against third parties.
My lord, you absolutely can in the context of, for example, guarantees. In that,
How is that affecting their rights as members? Sorry, as creditors.
my lord, in that regard, it is the same claim. In other words, the claim against the guarantor is the claim as against the company.
No, it doesn't.
What?
No, it doesn't. Claim against the company is to be paid a debt. Claim against a third party could, for example, be a claim against a financial advisor for the negligence of putting you in this company in the first place, or putting you in as an investor in the company in the first place.
Well, if my lord's moving outside the example of a guarantee.
I mean, even with a guarantee, it's not the same claim. It's a claim under a guarantee.
Absolutely a claim against under a guarantee, but in effect to recover the same loss. Hence the reasoning in the case is that
maybe not.
Due to the potential ricochet claim in against the company, that's the jurisdictional basis for allowing the scheme to do what it does.
But that's why I chose the example of the financial advisor, which is one that's featured in a number of cases and arguments. Somebody says, look, I've got a claim against the company. I'm not going to be paid very much, even under the scheme. The company is concerned that the creditor may then sue a financial advisor for putting them in there in the first place for the shortfall, and the financial advisor would just bring a ricochet claim back against the company saying, the only reason I told my client to go into your company is because you misled me in various information. Now that wouldn't on any footing be the same claim.
My lord, I think my answer to that is twofold. One, you need to deal in the capacity as a creditor from the Lehman Court of Appeal decision, and the other's dealing with the distinction between your rights as a creditor and your rights in some other capacity, number one. Two, one can go more broadly and reach claims as against third parties that the members of the class have, but only if the compromise of those claims is necessary for the effectiveness of the scheme.
Absolutely right, but I thought, and maybe if we had a transcript, I'd be able to see it. I thought you said that the only claims that a plan or a scheme could touch were claims which existed between the member of the class and the company in the capacity as creditor. And I was pointing out that there is a broader jurisdiction to give effect to a compromise of those claims to require creditors, for example, to waive rights against third parties.
My lord, and I don't, I mean, if I misspoke, apologies, I don't dissent from that for a moment. The focus, though, we say again, is the capacity as a creditor. It's looking at the relationship between the claim they have as creditor as the company, a claim as a creditor of the company, and the other related ricochet claims in the examples given by my lord. It's not a broader inquiry. I think that's the fundamental point I make. Those other examples, quite rightly observed by my lord, are all inextricably connected with the need to make the plan effective in relation to the claims that they have as a creditor against the company.
That's right, but I thought your argument was starting from the proposition that because this is a plan or a scheme, you just can't look at, you can't touch, you can't affect any other claims that a creditor might have other than as against the company qua creditor. And if you were stating it that narrowly, then I do think then it's too narrowly stated.
My lord, to be clear, I'm not. What I'm saying is when you seek to propose a plan with a creditor, it is based on their claim as a creditor against the company rather than another claim they have.
That I absolutely agree with, because the last thing I'd want to do is to undermine my one rare triumph in Lehman's.
Once one is through that gateway, the question of how further your compromise or arrangement can go depends upon usually necessary to make the plan effective. The classic example being a guarantee or indemnity ricochet claim, or the example my lord gave, for example, in relation to financial advisors.
Or bringing it a little closer to home, I mean, the commonplace releases that are given to, for example, claims against directors and advisors.
My lord, absolutely. I think when I said advisors...
Yeah, no, you were following my example, but I mean, just to be clear that everybody understands, I mean, you know, the court isn't adopting a very narrow focus. It starts with a narrow focus as between the company and the creditor.
And then one can go broadly subject to gateways.
But the court can look wider. And one of the questions here is whether, you know, we should be looking wider when applying this test.
And to be clear, just on the last point on advisors under the scheme or plan, we absolutely say that my lord was correct, first in Noble, then followed by a series of other cases, that the release of advisors and directors under a plan is an appropriate use of the power
Can be.
of compromise, subject to the particular facts of the case.
Can be. See Thames.
But
See Thames.
the necessity point and whether it's fair and appropriate.
Yeah.
The next point that I was going to do by reference to the case law, because I don't think we really turned up many of the cases yesterday, is to show that the focus of the court within the context of Part 26A cases, and indeed previously under scheme cases, when working out whether the no worse off test has been satisfied or not, is to focus on the capacity as a creditor and the incidence of liability in relation to that claim, rather than going more broadly, as suggested by the appellants, to include unrelated additional profits they would earn in their capacity as a creditor, which we say clearly is not within the capacity of creditor. There are 4 cases plus the CVA case, the scheme case that we saw yesterday. I'm in my Lord's hands as to the detail with which one needs to see them. I was just going to go.
This is quite important stuff. So
let me go to where we didn't go yesterday, and thank you for the guide. Can we start chronologically then? And by starting chronologically, can we start with the passage in the judgment of Mr. Justice David Richards, as he then was in the TNN case? And for that, can we go to the Court of Appeal's judgment in the Adler case, the AGPS case, which is Authorities tab 20, page 660. And can we go down so we can see 150 on screen? This is the point that my Lord Justice Snowden referred to yesterday in relation to pre-existing law under schemes, and a recollection that Mr. Justice David Richards had said something in relation to what I think in other cases has been called a baseline fairness test in relation to schemes. And the point that the learned judge was making in relation to fairness and the exercise of the court's power to sanction a scheme on fairness grounds is produced in the passage at the top of the following page, page 661. And what the judge says is he finds it very difficult to envisage a case where the court would sanction a scheme of arrangement which was an alternative to a winding up, but which was likely to result in creditors, or some of them, receiving less than they would in a winding up of the company, assuming that the return in a winding up would, in reality, be achieved and within an acceptable timescale. So, a couple of points in relation to that. The first is he's looking at a comparator in scheme talk, a relevant alternative in plan talk of a winding up. So that's the focus of the comments, a scheme proposed as an alternative to winding up. And in that context, he says, in clear terms, that he finds it difficult to think the court would sanction a scheme that would make people do worse than they would do under that winding up. And he does that by the use of the words in creditors, or some of them, receiving less. What are his guardrails to that conclusion? Well, you don't just take the headline number you would get by way of dividend in a winding up. You need to carefully consider, one, would you really get that dividend, so proper evidence of what the dividend would be, and two, the timing of that dividend really going into what would the present value of that claim be. Just taking facts, if in a winding up, due to complicated factors on a global scale, it would take 5-6 years to get the dividend into the liquidation estate, but under your scheme you were getting cash on day one, it may be a reason why the scheme is fair, even though it provides for slightly less than a liquidation, potentially, because the net present value of the liquidation return would be less.
now the context of this, of what Mr. Justice David Richards was saying, was that he was setting out an explanation of the broad approach to CVAs and schemes of arrangement in a judgment essentially directed to the US courts in TNN. And he had set out in the preceding paragraph the usual Buckley test that the court used to apply on sanction of a scheme which ex hypothesi would have had an affirmative vote in each of the classes, and the court is therefore, generally speaking, being slow to differ from the results of the meeting unless the class has not been properly consulted or the meeting has not considered the matter with a view to the interest of the class or there's some other blot. And what I think he was really saying is that there might be a rare case in which you had a class which had voted in favour of a scheme, but which, on the face of it, gave them less than they would get in the alternative, winding up. And the court, that might be a reason for the court to differ from the result of the meeting, basically on the footing that the creditors had taken leave of their senses, basically. Or it was indicative of the fact that they hadn't been properly consulted, or that there was some other factor operating within the class. So he's setting out the baseline, but as part of some sort of sanity check for the purposes of a scheme of arrangement. I mean, that's the background. Is that right?
My lord, it is, in that he is setting out a baseline, but clearly, to be in a class together, the court needs to be satisfied that the interests enable consultation. That said, as we know, there are many cases in which people have other interests, for example, and yet still form part of a single class. And I think what the judge is clearly contemplating by the words "very difficult to envisage" is that in a situation where any member of that class, even necessarily being an assenting class, because we're in scheme world and you don't get to sanction in scheme world unless you have each of the classes being assenting classes, he's saying that there is this floor below which your scheme cannot go, because if you do, it will necessarily be unfair, because your arrangement or your compromise is put forward as an alternative to a winding up, necessarily entailing, I would suggest, that it's a better result for the class than a winding up.
And the other thing, just to finish this before we start moving forward, but in the ... quote, that in the actual judgment, the ... are words. It actually says, "or not interfere with a CVA."
Oh, yes.
Because Mr. Justice David Richards was also considering, for the purposes of his judgment, the possibility of the approach under a CVA. Now, obviously, I took that out in Adler because we weren't dealing with a CVA. But that also indicates why, where there's a broader discretion to interfere with a CVA on the grounds of unfair prejudice, that the court would check that for creditors that they're not being forced below a floor.
We agree with that, and again, I think just picking up on the point I made a moment ago, which is this necessarily contemplates there's a floor below which schemes or CVAs cannot go where they're proposed as an alternative to a winding up, because the whole purpose of it being proposed is it's being said to the court, this is good for those who are being compromised.
Okay. Yeah.
And the point that we make, we say that as a matter of construction, as supported by the cases so far determined in the context of plans under Part 26A, what one now finds within Condition A in the no worse off test is applying a similar hard jurisdictional gateway, imposing a floor below which the plan cannot go, and then, provided it passes that floor, all of the other matters, whether they concern collateral interests, sharing of the restructuring surplus, etc., come in at the fairness stage. Because, of course, there is still a discretion made very clearly by the cases, and I think one point that was made in deep ocean, I'll try and find the paragraph in a moment, is it was suggested as a result of deep ocean that Mr. Justice Chow may have been suggesting that when you tick condition A, you've got a fair following wind, you will get your cross-class crown down, and the courts subsequently have been clear, well, no, that's not right. You just need to get past condition A before you can even have the court considering whether to sanction your plan.
So in your example of the guardrails put in place was timing and will you really recover? Would it be right to say that if I had a claim against the company and a claim against the guarantor, and the scheme purports to take away my guarantee claim, like the CVA in Powerhouse, for example, which would have failed the unfair prejudice test in Powerhouse, would I be worse off under the plan than under the liquidation because I lost a valuable right against the guarantor?
My lord, yes, in your capacity as creditor you would, because the effects of the terms of the plan would be to take away that right.
A right as against someone else?
Absolutely, but a right that is dealing with your claim as a creditor, in other words, the counterpoint to your claim under the plan.
So it would equate that with a right of security?
My lord, yes. The other point I was going to mention, we would also acknowledge that a right of security is something that needs to be taken into account. So it's not just timing of dividend. We don't suggest it is. We agree it would include security rights. We agree it would include a release of a solvent guarantor. We agree it would include taking the way in which my Lord Justice Snowden approached the issue in the Virgin Active case, taking account of returns that landlords may make from reletting their property on the open market to work out whether they're worse off or not, if under the plan someone is trying to force them into a worse deal. Now, normally that's dealt with by having a break or forfeiture right.
But sorry, can I just rewind to pick up my lord's point? You accept that, do you, that the removal of a claim against a guarantor would be something which could be taken into account under this section when assessing no worse off, the question of whether you are no worse off under the plan, if the plan purported to remove your claim against a guarantor, that would have to be taken into account. I thought that was the answer you gave.
No, we had posited that it would on the basis that what you are doing in those circumstances is under the terms of the plan. In this context, by a specific term of the plan, having that guarantee had a line struck through it.
Yeah, I mean, the standard provisions. Here's a plan that there's a power of attorney given to somebody to execute a deed of release on behalf of all creditors, releasing claims that they have against a guarantor. And you say that when determining whether the no worse off test, you have to take into account the fact that they lose the claim against the guarantor.
My lord, yes.
Yeah, and similarly in relation to claims, for example, against financial advisors or directors or others.
My lord, I think the necessary logic fails that in relation to something which is imposed under the plan, yes, because you are looking at whether they are no worse off under the plan than they would be in the relevant alternative.
Right.
I mean, let me, if I may, reflect on that in view of the way my lord put the question. That's my...
There's no particular elephant trap around here that I'm leading you to, just to be clear. I'm just trying to, because I understand the concern, I'm just trying to sort of, since we've started down this road, to make it clear, what the parameters are. At least there may be an elephant trap, but I haven't laid it. I'm just trying to understand where you're going. Just to be clear, so you don't need to look quite so startled or worried.
I was not intended to say if I betrayed that. What I think the core point we make is, shall I show my lords the
Yeah, no,
passages.
carry on.
And
But
we can explore as we go. The next one was devotion, which is number one in chronology in terms of plan cases. And that's Authorities Bundle 11-292.
are we skipping over the other? We're not going to APCO or Noble or.
My lord, I subject to the court, I wasn't going to go to those. I'm now looking at what the courts have said, similar to the passage we saw in TNN about the scope of the inquiry now in relation to the no worse off test expressly under section 901C.
Right.
If we can go to page 300, if we can go down to paragraph 34, please. It's paragraphs 34 and 35. At 34, the court introduces the no worse off test, and the court sees in the last sentence of 34, the primary question for the court when considering what will happen under a restructuring plan and comparing it with what is likely to happen in the relevant alternative is to look at the likely financial return in each of the alternative eventualities.
And by saying look at the likely financial return, has Mr. Justice Trower asked himself the wrong question, or at least depends on what he means by financial return. Because if he's asked if by financial return he means from the company, then by definition he's already defined the question too narrowly, hasn't he?
Well, now, can we see then what he says at 35
Okay.
in relation to that? He says, doubtless the starting point will normally be a comparison of the value of the likely dividend or the amount of any discount for the par value of each creditor's debt. However, the phrase used is any worse off, which is a broad concept and appears to contemplate the need to take into account the impact of the restructuring plan on all incidents of the liability to the creditor concerned, including matters such as timing and the security of any covenant to pay.
I mean, he's certainly right in that, but the question is whether he's actually defined that too narrowly in circumstances where you've just accepted that you would need to look at the effect, for example, on claims against third parties, which also were required to be surrendered under a scheme or plan. That wouldn't fit easily within those. It wouldn't fit within the likely financial return, and wouldn't fit easily within the instance of the liability to the creditor.
Well, just maybe picking up on the last point, the liability to the creditor. A recovery from a guarantor, taking the guarantor example, would pro tanto discharge the liability of the company to the creditor. Similarly, the realisation of security would again, to the extent of the value of the security realised, discharge the liability of the company to the creditor.
That's why I like the financial advisor stroke director example, because it pushes your test.
More difficult in relation to that.
You see, I think you're right to accept that the no worse off test would have to take account of a requirement under a plan that a creditor surrendered a claim against a third party, which potentially gave rise to a ricochet. Now, that could be a guarantor or security, but it could also be a less obvious form of claim against a third party where there's a risk of a ricochet back. And if that's right, then it becomes less easy to see that it's quite as narrow as, I mean, I'm not criticising Mr. Justice Trower, he probably wasn't thinking about the sort of possibilities that I've just put to you.
On the final point, we'll think about the final point a little bit more carefully. Clearly, what the creditor can't do in the example that my lord's posited, where you have your claim under your instrument that you bought, for example, from the company, and a linked claim against the financial advisor who advised you on selling it, what the creditor can't do is double recover in respect of any damage.
No, the creditor doesn't double recover. What happens, and this goes back to equitable life, for example, the creditor says, look, I'll get what I can get out of this dreadful company that I was advised to invest in. I invested 100. I'm only going to get back 10. I was given negligent advice by my financial advisor, so I'm going to sue him for 90. The financial advisor would bring a claim back against the company, saying, well, the only reason I advised my client to go into this company is because I relied, as I was entitled to, on the statements that were made by the company at the time. Hence, there would be a straight ricochet claim back. Now, one claim is a claim on the instrument, the next claim is a claim in negligence, and then the claim back is probably a claim in misleading financial information under FSMA or something. So, you've got different claims. But if the requirement to give effect to the plan was to require creditors to release the claims against the third party, I don't quite see that it's as narrowly drawn when you're looking at the no worse off test as simply saying, what financial return do you get from the company, or is it an incident of the debtor-creditor relationship in that narrow sense?
Well, I don't see that. In relation to the final example, it may be because they are not inextricably linked to the discharge of the claim against the company in the way that a payment on a guarantee or a realisation of security is.
Mm-hmm.
Is that rather than being part of the jurisdictional path for the no worse off test, there's broader considerations of fairness in relation to those additional releases. But can I just think about my lord's example a little bit more?
Yeah.
So that's the focus in deep ocean on all the instance of the liability to the creditor concerned. We then have Virgin Active, Appeal Authorities Bundle 13, tab, page 339. Decision of my Lord Justice Snowden. Just by way of summary, this is one in a long line of cases where plans have been used to compromise the claims of landlords, in particular landlords who the evidence demonstrated would be out of the money in the relevant alternative insolvency. And by that I mean there'd be no dividend for them apart from their share of the prescribed part. And I say a long line because the use of the plans in that context within Virgin Active and then a whole series of other cases, it essentially became key to keeping the high street going during COVID. That's a whole series of them. Now, if we can look at what is said, please, at paragraph 106, which is page 364. And it's really doing no more to show the court comment in the cases here, and it's the bit within brackets primarily but not exclusively in terms of their anticipated returns on their claims. So we do say that it's not suggesting any roving inquiry such as that which would necessarily be involved by the case presented by the appellants.
Well, they're not saying it's a roving inquiry. They're saying we're suffering competition law or competition effects. We're not asking you to rove anywhere. Just look at those. I mean, you know, so they're just saying don't restrict it to anticipated returns on the claims from the company.
To which,
I mean, I know you say it's too wide and it's too vague and all that sort of stuff, but I mean, all this was actually saying, and I do hesitate here because I can't remember what I thought at the time, unsurprisingly, but I think it's not inconsistent with what we've seen before. You look perhaps primarily at the returns on the claims from the company in the two alternatives, but then you look at things like timing, security, and I suggest you can look further afield if the terms of the plan do require you to give up other things, which you would otherwise in the relevant alternative be entitled to do.
and my lord, that's the third category, which I can just pause on for the moment, but we see the natural sense for the way in which that's posed if it is something you have to do under the terms of the plan. Then can we just see what was said in Smile Telecom, tab 14, page 411. At page 421. It's paragraph 30 where Mr. Justice Trower deals with condition A. And it's the bit beginning, in my view, to the end of the paragraph. If I could perhaps invite the court to read that.
This is an unopposed extempore judgment.
My lord, yes.
I mean, you know, it's Mr. Justice Trower, so
My lord,
it
yes,
deserves
I
respect.
recognise that.
In the same way Virgin Active was contested, but a very fast judgment in the middle of the pandemic in early days, not dealing directly with the question that we're now facing.
My lord, we recognise that. We were trying to show
No.
the court the statements that have been made.
Yeah.
We do, though, suggest that it is a straightforward and correct interpretation of the statutory condition, and to show it as being concerned with the persons in their capacity as members of the class.
So,
I'm picking up on my lord's question. Then, I'm so sorry, I didn't mean.
no, you.
I hope I'm going where my lord.
I was going to say, why don't you answer the question before I ask it, and then I'll ask you a different one, probably.
Well, the question then being, in relation to their claims compromised under the plan as a member of the class, are they worse off?
Yeah.
And if that is the question that is to be posed, then it's not simply the incidence of the liability, including guarantees and securities. On the wording of Mr. Justice Trower here, if you're looking at the effect on those persons as in their capacity as members of that class, it would include other things they're required to give up as a member of a class, including, on my lord's positive example, a claim against a financial advisor.
So, I mean, giving up the claim against the financial advisor, you're required to give it up as a member of the class, but it would be slightly difficult to say you're giving it up in your capacity as creditor. It's a slightly different thing, isn't it? You look at what the members of the class are being required to give up without characterising what it is. You're just saying, as a member of the class, they're being asked to give up a claim against a third party, which they have. And you should be able to take that into account.
My lord, I think that is the logical consequence. To be through the gateway of being subjected to a plan, one needs to be a creditor or a member to be within the ambit of Part 26A. Once one is within it, there are a number of guardrails about how far the plan can go. In addition to compromising your claim as a creditor, it can do other things, as we've explored.
Yeah.
If it does under the plan do any of those other things, those things can be taken into account. But it's not a broader inquiry to take into account things which are not imposed on the class by the terms of the plan. I don't know whether that was my Lord's question or not.
I didn't have a better one.
May I just show the court one more case, which was a fully opposed, fully argued case, and that's at tab 15, page 436, authorities. It's the case of great annual saving, and just to give the court the background for this, HMRC challenged the sanctioning of the plan on the basis that condition A was not satisfied. So they came to the court and said, condition A not satisfied, we cannot be crammed down. And can we see the argument that the plan company made to meet that? That's paragraph 58, page 449. So Mr. Weaver cases for the plan company. And can I just explain what it says then? I invite the court, if I may, to read the paragraph. He said that when conducting the no worse off test, if the plan was sanctioned, the company could keep trading, which would mean it would generate further tax revenue for HMRC, which meant that could be taken into account.
Slightly curious concept of HMRC being better off. I thought HMRC was just effectively the tax collecting authority for the government. It's not like a profit making entity in and of its own right, rather bizarrely.
Well, the submission was the submission, my lord. And I think putting it shortly,
Anyway, there we go. Yeah.
this, if the company failed, it would not generate any more tax revenue for HMRC because it would not have any further profits.
It's the for HMRC sort of concept. Anyway, there you go. Yep.
So we say obvious parallels with the argument raised by the appellants in the current case, although one, it's the flip side of it because it's the company taking the point, but two, it's actually much closer connected than the appellant's point in the current case because it is focused on benefits that may arise for the creditor after the plan is sanctioned from the company by reason of the payment of further tax. So there's a direct connection between the debtor-creditor relationship because it's focused on what would happen between the company and HMRC. Now, it was in our submission rightly rejected by the judge. Can we go to paragraph 82, please, at page 457. So my lords will see the submission. Mr. Weaver Casey emphasised the breadth of the words any worse off. He argued they require one to look at the overall picture, and undoubtedly looking at the overall picture, HMRC would be better off under the plan because of the future tax it could expect to collect if the company continued to trade. And the judge says that's wrong for two reasons. And just to be clear, the quotation above, if we can just go up a little to the previous page, is the passage in deep ocean. So that's what the judge has in mind. And if we can then look at paragraph 85. Again, could I just maybe invite the court to read paragraphs 85 and 86 before I say what we can take from them? A couple of points. One, what the judge envisages, we say correctly, is comparing the financial value of the rights to be compromised by the plan on the one hand with the likely recoveries in the relevant alternative on the other. And just maybe picking up on the questions posed a little earlier, one will see that in paragraph 85, when the judge considers what inquiry Mr. Justice Trower had in mind, this is the fourth sentence of fourth line of paragraph 85, he says it's whether the relevant class of creditors are likely to be any worse off as regards the existing rights the plan seeks to compromise.
On its face, that's not limited necessarily to rights against the company.
My Lord, I think, to be clear, that my point would be that would extend to the three categories we've been touching on this morning.
Yeah. So you would say you look at everything which you're being required to give up under the plan, namely your claim against the company or some aspect of your claim against the company, some aspect or your claim against a third party in our scenario, and you ask what is it that you would be able to do with those rights in the relevant alternative. What would they bring you in the relevant alternative?
So just taking the guarantor example, the reasoning applies through to all of them. If there is a guarantor, what would be likely to happen to that guarantor? Would it also collapse into insolvency,
or would it be
solvent?
Yeah, and if you're getting 100p in the pound from your guarantee claim and you're being required to give it up, then if you're not being offered 100p in the pound, then actually you're going to be worse off under the plan, to put it bluntly.
That's an unsurprising result in view of where the court got to under the Powerhouse decision in relation to solvent guarantors in the context of CVAs.
Yeah.
If you would get pence in the pound in the guarantor's insolvency because there would be a group-wide collapse, are you getting enough under the plan to pay you for the release of that right?
Yeah.
So we do say that that is the focus of the inquiry, and not, as the judge said in this case, on a broader range of potential claims which are not things that arise as regards the existing rights the plan seek to compromise.
You see, the judge, I'm not quite sure I understand paragraph 86, which which is where he actually decides the point. Can you help me with paragraph 86? Because he does appear to suggest that you can take it into account, but he says it's too remote.
Well, I think that's no more than shorthand that it doesn't fall within what he's stated as the gateway at 85. That's the way we read it. If it's suggesting some different sort of test, then we would dissent from it. My lords, can I just now turn to policy and why we say the construction advanced by the appellants would be contrary to the policy and purpose of Part 26A and would give rise to consequences which can't have been intended. I now recognise I'm doing what my Lord Justice Snowden reminded me at the beginning that these points relate to ground one as well. So I would suggest that both the policy and the unintended consequences both assist with the construction of the provision itself. We've seen the wording on the page. These are the points to go alongside the wording on the page. Can I please start by showing the court a passage from the government papers which had been relied in a whole host of cases as showing the policy of the Part 26A jurisdiction. But can I take a Court of Appeal case which has it, which is the AGPS case, Authorities Bundle 20, page 680. I'm, with apologies to the court, because I was going to come back to this case, it may be easiest if I could invite the court's indulgence to read 248 through to 250, which includes the government paper, which should hopefully make things quicker later on.
Sorry, which paragraphs?
Paragraph 248, please, first, where the judgment deals with the way that out-of-the-money creditors were dealt with in the context of schemes before the introduction of the Crown-Down power. Then the quotation at paragraph 249 from the Virgin Active case, and then 250, the introduction to and the quotation from the government paper.
Okay. Just to be fair, you actually need to go back earlier in the judgment to read the whole of what the government said, because the introductory passage from the government's explanatory notes to the Act is actually set out in paragraph 106 of the judgment. So just in terms of hierarchy, the explanatory notes are what actually accompanied Part 26A, because what you've taken us to at paragraph 250 is a earlier consultation which didn't in fact lead to the enactment of Part 26A.
Well, that's absolutely correct.
Right, so just to put it into proper context, the explanatory notes, which are the ones I set out at paragraph 106, are the actual notes that accompanied the introduction of Part 26A, and they do say something about the purpose of cross-class cramdown.
My lord, they do at paragraph 9, absolutely.
They do, and it's to prevent, sorry, it's in essence to remove in an appropriate case what would otherwise be the right of veto that a dissenting class would have under the scheme regime.
My lord, yes. And while, if we're there, what is made clear at page 106, page 650, paragraph 15 of those explanatory notes, just below letter E, cross-class cramdown must be sanctioned by the court and will be subject to meeting certain conditions. As in the case with Part 26 schemes, the court will always have absolute discretion over whether to sanction a restructuring plan. For example, even if the conditions are met, the court may refuse to sanction a restructuring plan on the basis it's not just and equitable.
Yeah.
Going to our point that it's a minimum threshold condition.
Right. Why do you say minimum? Well, so it is a threshold condition, that's true, but I don't know what you mean by the word minimum. I mean, it's an important safeguard to the exercise of the new cross-class cram-down power.
I think I completely agree with that. I think by the word minimum, I meant more than a plan company cannot even seek to have a plan sanctioned.
It's a threshold. It's a threshold.
Precisely.
Right, but it's you're not suggesting that it's should be interpreted as a low threshold for some reason, are you?
I'm saying that it is a threshold which should be interpreted in accordance with the purpose of enabling cross-class cram-down to occur, that not being necessarily the end of the matter, the court still having a broad discretion, and as indicated in the government response as to one of the reasons why that you bring that in is to deal with out of the money creditors in the passage that we saw a moment ago at paragraph 250, page 680.
Yes, but you have to be careful with the timing of this. When the passage at 250 was written in response to the consultation paper, they did not, can you check this, but they did not consult on the no worse off test. That was not part of the consultation as I understand it. I mean, there was a much looser consultation, but I don't think, but please can somebody check this, that the consultation which is referred to in paragraph 250 had, for example, attached to it the draft wording that we now see in 901G. I'm almost certain it didn't, because I'm almost certain that 901G came sort of pretty fresh in the pandemic and hadn't been consulted on before. So, I mean, if your submission is that 901G is particularly aimed at out of the money creditors, I think you're adding 2 and 2 together and making 5.
My submission is that as part of the policy of the introduction of Part 26A, as reflected within the analysis at paragraphs 248 through to 250 of Adler, one of the policy objectives was to ensure that you could bind out of the money creditors and shareholders. That's the submission I'm making.
Right.
I'm informed it does appear in the consultation, but let me check over the.
I was going to say it might be a
Sure.
convenient moment to take a mid-morning break in any event, but if you can check that, because I'm not sure that I recall the exact wording being included. If I'm wrong in that,
No,
then
well, of course not.
do put me right. Good. All right. Well, we'll take 10 minutes.
All rise if able.
Yeah, they're clerks. Yeah, the clerks are supposed to do it. Yeah, so I'm really confused.
Well, that's that case, I think, so that's
Yeah, just go to now.
We haven't been told that there's no laptops have been provided to them. They don't have the transcripts, which is what you're. That's what I. No, that's what she's doing. Oh right. Yeah.
And it seems like they only have one.
And because yesterday, I don't know if they had it yesterday, but I think they're using their own laptops, so we don't have their credentials to log them in. So perhaps their clerks did it yesterday.
Okay.
I'm not sure, but we don't have their. It's obviously personal to them, their login. Do you think that means it's fine, or I just don't know who can log them in? I don't know who logged them in yesterday. Yeah, I'm not. I think clerks must have. I thought their clerks did, but. Is there it seemed like he wanted the transcript. Yeah, when he said that, I was like, that's strange. I thought you had it. Is there a headlock? Yeah. No, they don't have any Opus laptops. So basically, I can't do anything because they've got their own devices. So I don't know. Maybe email. Yeah. Should I do it or yeah. I mean, I think they want it. I think he wants it now. It's just strange because they had it yesterday. Yeah. Maybe she'll email the clerks, maybe, and the judges' clerks, and see if they can. Yeah, that's a good idea. Yeah.
Do you have their email?
Oh, I'm emailing the case manager. Who'll have to email them.
I mean, I could.
Oh, she's out there. Who's Carl? Maybe Fabian. Fabian's been messaging me today.
Do you want me to contact the clients?
Yeah, maybe if you could just ask them if did they log them in yesterday or. Yeah.
So I have obviously Snowden and Zacaroli. Yeah.
I'll ask from my end as well. See what happens. Thank you. Thank you very much. Is that point in paragraph?
So do you want me to ask them what kind of access they have to the transcription? Or
Just did they are they logging in the judge into the real time?
on their personal laptop?
Yeah, will you be logging the judges in to see the real time? Yeah, thank you. Yeah, because these they're not open. Yeah, no, they're not. So yeah, we can't.
What counterfactual?
What's the answer?
Yes. Completely agree.
Is that it? Definitely.
Hard to like word it, isn't it? No, this is going over the top. The amount of times I've worded things and they're like, yeah, you've got it already. I'm like, no, that's not. I don't think that's what I was asking you.
Yeah. Okay. Yeah, but anything else?
Yeah.
Does one agree?
Yeah, if we threw that as well, then I've got a message saying, oh, there's been enough. That's all. Yeah, you can't even.
The kids don't have to come out.
No, honestly.
Because.
And it hasn't been referenced yet.
Alan sent us. Asked Alan for the overview of this week, and he sent me next week.
He's sitting next to you.
It's like 9 to the 3rd.
Remember to still add it into the Slack channel just so that they know. Yeah, I suppose. I just didn't see.
I will.
On Monday.
Actually, I don't even know how to pronounce it.
Yeah, I know. I saw that, and I was like, "Well, that's not this week." You were definitely.
Just say who's looked at the judge. Yeah, that's good.
Yeah.
Just
Well,
those
great.
logged in the judges. They have to logged in this morning.
Oh, he's very kind.
Yeah.
Is it club? CLER. I'm going to do it now. Yes, thank you. I just worried that they're going to think that yeah, they didn't say that.
July.
Yeah, yesterday was fine.
Yes.
Yeah, exactly. I had it before in the last time they sent it to the Slack channel so I could do it every other time. Yeah, but I think it's also the
These bits where?
passage is where I'm like, we tagged it. Yeah. Yeah, so Felix not I don't know who that is. Oh, fair. Oh, you stopped I love it when I see that. And sometimes little things to try and keep myself. It will come up. You have the 3 logins.
He said he would
I'll be like, can we have laptops to 67, please?
Literally come in here every session to put something.
No, literally. Something's always. Oh, he's typing. Something's always going wrong. Yeah, that's why, like, when you asked me, like, I was like, no. No, exactly. Well, yeah, he definitely said it, and I was like, the judge or the clerk should be doing it. Let us know if they need details reset it.
See someone in Australia though, from unexpected, you'd be like, are you a ghost?
Yeah, exactly. And we are.
What are you going to be?
First I wasn't doing that because I thought they tend to get to know. So I was avoiding it, and then Ariane was like, no, literally anything. I was like, even if it's shit, anything. Because it's better, so it's there. Because you say it on the Slack channel, you've got the
But I used to do the EPA operations.
Do you know that?
yeah.
So it's just stupid.
No, oh no.
You know, I could have but
The good thing is tech is closed. They're always there. But there was one case where I think it was the first and I'm just like 14 fucking tech come and they just keep telling me how to do it myself. That's like really great, but I just at this point just went so wait, so the one I was telling you about earlier was
Like the people who do these and so
but the first one was so stressful.
There was a real issue. We got to compromise the race. We were
saying that they decided to get rid of the encryption screen so it's not taking too much space.
No, that's what I just said.
Yeah. Okay, fair enough.
Fair enough. That's
Yeah.
Yeah, we just wanted to show.
The small screens are just for the bundles. Yeah. Fair enough.
A bit weird then.
Maybe there's a disconnect between them. I'll ask her. Sure, there's Snowden who mentioned it was just
Yeah.
Thank you for checking.
Yeah, exactly.
You just and then you just
Chinese restrictions.
well, you have to stop and wait.
Who knows?
Depends on his job.
Two of my last case and I was there. He was right there. Exactly. And it was like I could do basically a fire alarm. And so we had to go and we come back in. And my was completely frozen. It won't work. The live transcript is so tough. The clients, they tell the judge. He fully just goes, I'm sorry.
It's me. I'll report back to the
It was like a script.
Wait, are you having to hold one? No. No. Wait. I've heard of it, and then I couldn't remember his name. So then when I had him, so then I was like, there's no way that's the one that everyone was telling to watch out for, and I was like, no. But his friend's she's one of the kids. Oh, wait, one of the main characters. Yeah. Wait, it was the girl, the unofficial girl. Yeah, shut up. She's that was like, she was my favorite girl. Yeah. The original.
We need that full singing. Oh, no, someone to take.
No worse off was mentioned, but without the express drafting, I think is the message I've had.
It is. Can I maybe just very helpfully, from the skeleton argument of that was put in below, if we go to supplemental tab 25, page 972. It's Mr. Thornton's skeleton argument from below. So at 62.1, one sees the introduction of what was being consulted on. And it's included a condition of all creditors will be no worse off than in liquidation. Now, clearly that's changed to the statutory test now, and the focus on liquidation was dropped following the consultation. But that was what was consulted on. And then 62.3 sets out the question that those consulted were asked. And the answer to that is Authorities Bundle 20, page 680, where my Lord Justice Snowden sets out the government response.
See, they moved the requirement from the scope of fair and equitable, which I suggest is probably discretion, into a jurisdictional threshold requirement.
I think the short answer is yes. The way it was posed in the consultation paper is that it will be considered fair and equitable if you meet certain gateways.
I'm not making a point. I think earlier on the thinking was much looser, and they dropped the fair and equitable test completely, just in favour of a discretion in the face of it unbounded. And they moved, I think, that test as whatever it was into 901's G. The first bit of
and then
901G.
rejected the absolute priority test.
Yeah. Good, thank you.
And that was the key think we wanted to show the court on policy. Then a few comments on consequences to go alongside our way in which we say the statute should be construed. We do say that if one goes outside looking at what is compromised under the plan as the focus of the no worse off test and considers what the appellants say is the broader inquiry, so as to include profits that they would earn on a collapse of the Petrofac group, that's their case, that would be undermining the purpose of the rescue culture and rescuing the company in the interests of the stakeholders as a whole, the creditors and the others, such as employees with stakes in the business. Now, we do suggest that it is far from rare and indeed commonplace to have a plan in which a competitor of the company is the creditor. It's very common in retail businesses, the way that supply of stock works, but to give the court maybe a hard example, the first case that came before the court under Part 26A was the Virgin Atlantic plan. As we explained to the judge at first instance, the first point is obvious, the second is more detailed. Virgin Atlantic, of course, was an operator of international flights around the world. It competed with other airlines on its routes. One of its competitors was Delta Airlines, which competed with it on the New York to London route. It was a considerable creditor of the company. Now, if the appellant's argument is correct, on the facts of another airline case in the future, it would enable a competitor airline to come to the court and say, well, no, if this company collapses, we can now exploit additional passenger traffic opportunities on the routes which it currently flies. The profits we would make on those flights need to be considered when looking at the no worse off test, because it is on their case a very broad view, and that the court doesn't even get to the discretionary stage unless they are paid the full amount of what they say, or what ultimately the court quantifies those losses may be.
Mr. Thornton, I think, accepted that wasn't his case. I think he said it didn't go that far. The fact that you're a competitor isn't enough. It all hinges on the fact they're joint ventures in this case. That was his case. It's much narrower than that, I think.
I think 2 points on that. That's a helpful clarification, because I think we thought it was put more broadly.
I got a nod from Mr. Thornton when I said that. So.
The second point is, it's never been explained to us why the joint venture agreement makes all the difference, nor do we respectfully suggest it was explained to the court. At the moment, vehicles sitting below the planned company and Saipem and Samsung are all parties to a joint venture under which they are carrying out a project for Thai Oil. Now, that's just one part of the group's business, but a significant contract within it. Under that joint venture, they are all jointly and severally liable to Thai Oil for any claims that Thai Oil has in relation to the project, subject to an allocation of liabilities ultimately between them, roughly a third, but with minor tweaks around the edges. There's been no suggestion or reliance on any term of the joint venture agreement which suggests that the appellants have any right to take business away from the planned companies in the event of an insolvency. There's nothing in the joint venture agreement, as we understand it, dealing with the insolvency of a party at all. There's been no attempt by the appellants to focus on any particular provision within the agreement that enables it to put its case. They say simply that if one has a joint venture relationship, that will mean one can take into account profits that would be earned on future contracts. Now, I think the logic breaks down in two places. That very general statement of principle that doesn't, in our view, have any fastening in the statutory wording. Number two, there is no impact on the ability of Saipem and Samsung to bid for such future contracts under the plan. They still continue to bid in the market as they wish, unhindered. And I think the point going with that is, to the extent that they were to earn future profits in the event that the group collapsed, there is no suggestion by Saipem or Samsung that those profits would in any way impact on or reduce the claim they have against the company for contribution for any sums that are owing as a shortfall to Thai Oil. So I think from our perspective, the loose appeal to a joint venture relationship doesn't really advance the position, because the assumed future profits still have nothing to do with the plans against the plan companies and what the plan does to those claims. That's our answer to it. One, I suppose, obvious point to make in relation to that is, if that really were right, we can foresee that there are numerous cases in which there are, within the company's business, as one part of it, a joint venture relationship. We at the moment struggle to see how the statute can be construed as a matter of language, or should be construed as a matter of common sense, to make sure that they are entitled to something very different under a plan in terms of a jurisdictional threshold than other creditors.
Can I suggest one possible way of looking at this, which was hinted at in the middle of that submission that you just made? When you're determining class, you look at rights which you have before the plan, and rights which you are being asked to surrender by the plan, and compare them with rights that you are being given as a consequence of the plan. And I use those expressions broadly to include not just simply the plan itself, but the ancillary gubbins that surrounds modern plans these days. You would look at all those rights, and it's a comparison of rights going in and rights coming out to determine class. Class, as we know, features is the central feature of 901G, is the focus when answering the 901G question on rights, as opposed to opportunities to earn profits or anything else.
My lord, in short, yes, we say it is. It's on rights and balancing against that what is done to those rights under the plan, including, my lord's broad
Well, rights against third parties would, if they are affected by something done pursuant to the plan.
My lord, yes, taking the guarantor example, or the realisation of security, yes.
Or claims against advisors.
Or claims against advisors if they are compromised under the plan.
And your challenge, I think, therefore, to Mr. Thornton, in that last series of submissions you made about the joint venture agreement and how he brings the joint venture agreement in, is show us your rights.
My lord, in short, yes. And there, I mean, at the risk of repeating, there is no suggestion that there is any particular provision or term within that relationship that is being in any way impacted under the terms of the plan. accepting that the test is now put as narrowly as a joint venture party, which we say is still wrong for the reasons I've just explained. In addition, there are practical difficulties with that which aren't faced up to. Mr. Thornton alights on a sufficiency of connection test to try and work out what is in and what is out. We asked two questions there. How can the company work out, when putting a plan together, whether something is sufficiently connected if on its face the plan is doing nothing as a matter of rights in relation to that claim? And the appellants haven't answered that. And secondly, even if one goes further, how on earth does one identify the potential benefits in the first place? Does the statute, I think it does on Mr. Thornton's construction, require the company to interrogate all the potential benefits to a joint venture party if the planned company failed? It requires the planned company to quantify those potential benefits and to do so with sufficient certainty that it can be satisfied that it can pass the no worse off test, and indeed within passing that test, because it is their case on the facts of this case, need to make provision for $340 million to a group of unsecured creditors who are at least $600 million out of the money in the relevant alternative.
But if looking at the no worse off test in the relevant alternative did require you to look at the financial consequences of interference with a right, so let's just take the claim against a guarantor, and if that required you to assess the ability of the guarantor to pay, and that might be difficult, well, the court often has to answer difficult questions. I mean, the difficulty, I sort of do wonder whether the judge was right in this, in paragraph 70, but the difficulty of determining the financial effect of something has not normally been said to defeat the court, and nor should it. It may require evidence, but the court often has to do difficult things. But
if I make 2 points in response to that, the guarantor example, as the court knows, is normally met by the company being able to provide the information by way of an entity priority model to show what would happen to that guarantor.
Well, the guarantor could be completely outside the group. I mean, or take my financial advisor example. It may require some detailed investigation as to what the position of those claims against third parties would be, but so what?
Well, my lord, in that case it may, and that may be a reason why one doesn't take on the burden of trying to compromise those claims in the first instance under the plan. And that may be the answer to that.
Maybe, but but if somebody tries, and this is an industry that's notorious for trying and pushing the envelope,
then the company would, in the context of the no worse off test, because it is doing something to those claims under the plan, need to be able to bring that evidence before the court.
But the fact that that may require then a bit of a battle on evidence at sanction over that question shouldn't mean that you don't have to answer the question in the broader sense.
Well, I don't dissent from that as a general statement. I think my point was a more practical one in terms of the operation of plans rather than the ability of the court, which is, how does one get the information to know whether your plan is a good plan? How do you get the information from your competitors' books to work out what their likely profit margin is on contracts going forwards, what their likely share of each of the markets would be going forwards? So you, in a situation in which the company is likely to be precarious financial situation can put a plan together.
But if, okay, I mean, I don't doubt that's maybe difficult. I mean, competition lawyers spend a lot of time and effort on difficult questions. But if, for example, a term of the plan was that somebody who happened to be a creditor had to stop operating in a particular market as a term of the plan, if you were bold enough to put that into your plan, then it would be upon you as the company would have to bring forward the evidence to demonstrate that, subject to that restriction of rights, they were nonetheless no worse off.
On my Lord's positive example, yes, save that I would question whether one is even within the jurisdictional ambit of Part 26A seeking to impose that on someone in relation to their future business conduct.
Well, I mean, I'm not sure it's materially different in term. I mean, let's be clear, the way, although everybody talks about releasing claims against third parties under a plan, it's not done under the statute directly. It's always done as an ancillary provision authorising somebody to execute a deed poll on behalf of the creditors.
Yes.
So it's done under an ancillary provision. So let's assume somebody as an ancillary provision said, in the same way that you say to a creditor, henceforth you cannot bring a claim against your financial advisor. That's just restricting somebody's rights for the future. If under the plan they said, henceforth you shall not operate in a competition with the company, because we see that as necessary to ensure that the compromise has effect. You know, we want you, if you're a competitor, to cease operating in competition with the company. Now, I'm not suggesting for a moment that anybody would be bold enough to put it in as a business proposition, but as a conceptual possibility, if somebody put that in, it's not so materially different from saying to somebody you can't pursue a claim against third parties. But you'd have to assess the impact upon rights. It's a question of rights, isn't it?
My Lord, it is. I absolutely agree with that, but the only reason I'm being reluctant to say yes is, again, from my perspective, would question whether that sort of imposition of that sort of obligation, the obligation not to compete with someone in a defined market, would even be within the purview of the jurisdiction of the court, rather than coming only to no worse off than discretion. I think that's my concern about agreeing.
I certainly, in case anybody out there is getting any ideas, I don't dissent from that proposition, but I'm just pushing the envelope.
So
I mean, you know, all I'm saying, I thought your submission was generally, look, this will all be very difficult, and therefore it shouldn't be written in as a jurisdictional test. And I'm saying, is actually the real question is it an interference with rights or not? If it is an interference with rights, the fact it's difficult to quantify is why the end of there. I mean, you just have to do it. If it's not an interference with rights and it's just an ancillary consequence, you say it doesn't fall within 901G.
well, we do.
And you don't need to sort of say, and what's more, it'll be very difficult.
My Lord, we don't. We were simply explaining why, as a matter of policy and common sense, that result would, in our submission, not be workable. But no, we don't need to go there. The core point we make is that if it is not something which is imposed on you by the plan, you being within the ambit of the plan because you are a creditor, then it's not something which is in the mix for the purpose of the no worse off test.
Yeah.
I think, subject to my Lords, in the series of those questions, I've addressed most of the points that I was going to, apart from one, which is our respondents' notice, which I should mention, the judge in our submission got the right result, as we say in our skeleton, but perhaps for the wrong reasons. And to the extent that his test, properly construed, is rooted in a concept of remoteness, we don't stand by that. We stand by the test as explained in our skeleton orally to the court today. There was one further point to deal with, to the extent the court thinks it would assist, and this was the suggestion made in the skeleton and again orally, that there is unchallenged expert evidence that Saipem and Samsung would accrue a benefit of $340 million if the group collapsed.
Round two.
My lord, thank you. At the risk of over-speaking, can I just, in that regard, say the judge at paragraphs 35, 37 and 38 made clear no cross-examination testing was done because of the way he wanted to look at the issue. Ground two, exercise of the judge's discretion to sanction the plans. There's no suggestion by the appellants that he applied incorrect legal principles, in the sense that the relevant cases were set out at paragraph 39 of his judgment, and we say he clearly had them in mind. There are a discrete series of points raised on horizontal fairness. We'll explain at the end why we say that's an unfair criticism of the judge operating under pressure in circumstances where those points were not pressed orally, and he makes clear in his judgment that he was considering all evidence and submissions before the court, and in view of that found the plans to be fair. I think the key target of ground two, and this is really the point dealt with already by Mr. Colclough after the court asking for more on it, is the new money, the fairness of the new money, and the findings of the judge made in that regard. So if, as we say, the judge was open to make the findings he did on the evidence on the new money, having done so after cross-examination of the key witnesses, then we say that the decision should be upheld and there's no basis to interfere with the judge's decision. There was a...
Before we get it, I don't know how you were going to do it, but we see that the agreed summary of key figures has appeared. The one thing we definitely want you to do before we break at lunchtime is to take the time to take us through it.
Maybe I'll go straight there. Can I tell my lord what I was going to do, and you can, then I'll probably jump straight to that.
Well, it's a document you're going to leave us with to look at for half a day, and so it would be useful if we actually had a look at it now, so we can think about it before we resume on ground two. What would be unsatisfactory is if we were sent away on our own to read it, not understand it, not be able to ask questions on it, and then have to come back tomorrow morning to pick it up and deal with it again.
My lord, understood. Let me put that to one side and focus on the document.
Well, as I say, if we can do this quickly, then resume by all means, but I don't want to be sent away to read
we'll
it.
start here because it may take longer. What we endeavoured to do overnight, following the court's indication, is to deal with 7 topics and summarise the evidence in relation to those topics. And I think the genesis of some of the questions was the worked example without any supporting references, but paragraph 15 of the appellant skeleton, where they suggested for $100 of secured claim, the ad hoc group would get to do $44 of new money.
Well, it was certainly one of the issues.
So can I start with that one under the heading new money? Paragraph 3. It's agreed that these are the constituent parts of the new money. And we'll go through a breakdown of it in a moment. But in summary, it is 430 million, which is coming in round figures under the terms of the plan, with the hope, although not currently secured, a further obtaining of 14 million. That's the 9 and the 5. They're not put in under the terms of the plan. And that's dealt with at paragraph 4, where it's explained that the 9 million and the 5 million, they haven't been taken place. The restructuring is not conditional on those funds being raised, as explained in the explanatory statement.
And do you disagree with the last sentence, paragraph 4?
No, we don't. I will know.
So, as well as the appellant's petition is, so you can say it's common ground that.
No, no, we can. Then the new money breaks into 2 broad buckets. One is the $350 million that we saw on the previous page, and the second is the CBG notes, which we saw, which is the total of the 30 and the 50 million in the table on the left-hand page. Can I deal with the 350 million breakdown first? That begins at paragraph 5. And for what it's worth, there is a detailed treatment of each of the different elements of the new monies and the fees in the convening judgment of the judge. We're trying to distill it to one page here, but it's common ground that that summary is accurate as well. So there's 350 million of new money, which is divided into 2 between new money notes and new money equity. So there's 131 million of new money notes. Who can participate in the new money notes? 2 different groups of people. The first is all of the senior secured funded creditors as a class. The ad hoc group hold around 35% of those claims, but the entirety of the class is able to participate. The second element of the new money notes is the $37.5 million to be provided by Nuttree. The court will have seen that Nuttree is referred to throughout the documents as the new financial investor. And at the time that it committed to provide the new money, it was not a creditor of the group. So it's a third-party external investor that's been found.
But it is now. It is now a creditor.
I'll come to that in a minute, absolutely. And that, again, was understood and made clear in the judgment, as the court will have seen. The second element of the new money is 218 million of new equity, which it breaks down this time into 3. The first is an amount of equity equal to the amount of new money notes that can be provided by the senior secured funded creditors as a class. So again, it's the whole of the class allowed to do that, not just the ad hoc group. There's then $37.5 million by Nuttree, and there's $87.5 million by additional equity providers who are a mixture of current shareholders and new investors to the group. And maybe before we move to paragraph 6, the key takeaway from the way one can see the new money being made up, as I alluded to at the end of yesterday, this is a case in which there's been real problems in raising the new money. It's been incredibly hard to get the participation rates up to where we needed them. So it's not one of those cases that the courts often see, that the new money is just being done by one group of creditors. We've had to go cast a very wide net, new investors, current equity investors, and then also, for parts of it, to the creditors. Paragraph 6, what can the scheme creditors as a class, taking Nuttree out for the moment, do? They can participate in 187.5 million of new money. That is adding together the figures at 5.1a and 5.2a. So that is a combination of the new money notes at 1a and the new money equity at 2a. So that's the new money offered to the members of the class. Why have we called that the backstop money? We called it the backstop money because the company, in the normal way, needed certainty that it would raise the money. How did the company get that certainty? It did so by a group of backstop providers agreeing the money would be provided come what may, irrespective of take-up.
Come what may, subject to approval of the restructuring plan, obviously.
No, I'm so sorry, I missed that.
It's come what may on the condition that the plan is sanctioned.
Oh, no, absolutely.
Yeah.
Absolutely. So that's what the plan creditors in the senior secured class get under the plan by way of participation right. Then Nuttree at 6 sub 2. It is vital, again, accepted on the evidence, no cross-examination on whether it was vital or not, found by the judge that they were vital. It is vital because it's putting in $75 million of the new money, and it's splitting that between new money notes and new money equity. And it's also vital because it does the lion's share of the cash collateral under the CBG notes. Now, they don't give rise to any equity entitlement. Paragraph 6 sub 3, the additional equity providers I've already mentioned are new equity investors and current shareholders, the net being cast as wide as possible. Paragraph 7, we give court the reference to the convening judgment, which does contain a detailed treatment of...
Sorry, the additional equity providers are who? Shareholders and...
new investors, roadshow by the company, as explained by Mr. Sousa, to try and find other people to put money in, it being clear that the ad hoc group wouldn't meet the funding need and we couldn't get enough from Nuttree to meet the funding need.
And the reference to that evidence is?
May I give my lord that reference in a moment? I have it somewhere in my speaking notes.
It includes shareholders and directors, does it?
My lord, yes, it does. That's also dealt with within the convening judgment, that point at paragraphs 82 to 92. The new money notes, paragraph 7, paragraph 7, first point, it's common ground that the judge summarised all of the new money correctly within the convening judgment. Well, just to give you the reference, if you'd like to scribble it, or we can update the document. It's supplemental bundle, tab 1, page 68, paragraph 10.15 of Mr. Sousa's first statement. Then the new money notes at paragraph 7 give rise to an additional entitlement to obtain reinstated notes at a discount to the value of the new money provided. In other words, increases your claim. Again, the evidence being that's the price the company had to pay to raise its new money. Paragraph 8, and I've been going to the crux of some of the points that were made yesterday. Who could do the new money? The ad hoc group could do it pro rata alongside the rest of the secured class and ABN, which, although not a senior secured funding creditor, it is also a secured creditor and was given pro rata participation rights. And then what does the ad hoc group's claim translate to? It translates to around 35% of the debt owed to the senior secured class. Paragraph 9, I think, does no more than has it by way of a neat table what I've already explained to the court. Paragraph 10, picking up on a point made by my Lord Justice Snowden a moment ago, what about Nuttree? Yes, it is now a plan creditor, but it wasn't at the terms it committed to provide the new money. What else is important about Nuttree as found by the judge in the judgment, namely that if the group were to collapse now, if the court doesn't sanction the plan, it acquired its 23 million interest at such a discount that it would do better in a liquidation on that debt than otherwise. So in other words, in terms of if the court's looking for motivation, it's a zero-sum game for them. The fact that it has debt, is not relevant to which way it goes.
Zero-sum game?
In terms of its debt.
It's bought into the debt below the alternatives in the relevant alternatives. So it's going to win whichever way. It's just a question of how much.
My Lord, I was looking at it. Well, maybe we can turn up the list later in the submissions.
Okay. It buys the debt at less than it would get in the relevant alternative and a lot less than it will get if the plan is sanctioned. So it's going to win either way. It's made a good deal.
Yes, I think the point that I was making, perhaps very inelegantly, with the phrase zero-sum game, it doesn't drive the new money. The 23 million can essentially be pushed to one side when looking at its new money. To the extent that anyone suggested that its 23 million was key and that it wouldn't walk away from the plan companies if the plan is not sanctioned, the judge found that's wrong, because on that 23 million, it's still going to make a profit in the liquidation. That's the point I was making. Then the CBG facility at paragraph 11, again described in detail in the convening judgment. It's 80 million cash that the group needs to cash collateralise existing contracts. So it's to enable the continued performance of existing contracts. It's provided $50 million by Nuttree and $30 million by one member of the ad hoc group. There's no equity entitlement attached to providing that cash collateral, but there is a right to receive just shy of 20 million of notes on the same terms of the new money notes, and Nuttree gets a cash payment and a contingent value right instrument if the group hits certain enterprise value targets. So that's the new money and the breakup of the new money, who does it under the terms of the restructuring. Then the backstop fee. As the court knows, we say two things. One, there was evidence that we needed to pay a fee to get the money commitment. Two, as a matter of authority, we say that's a good justification for paying the fee. The evidence shows it was keenly negotiated, and these are the fees. It is 62.6 to 73.6 million in combination of equity and notes. And again, accurately set out within the convening judgment, as we say at paragraph 14. What about the backstop? Yes, the members of the ad hoc group comprise some, but they do not comprise all of the backstop parties. As the court sees at 15.1, everyone within the senior secured class who committed to backstop by the launch of the restructuring is entitled to an initial backstop fee, and there were institutions outside the ad hoc group who agreed to do that. And then number two, the backstop premium, the second part of the fee, that was formally made available to everyone. And at subparagraph 2, the fees for doing so are stated there.
Sorry.
Others within the class have participated. Clearly, if everyone had participated pro rata, there would have been a completely even sharing of the fee. As it happens, some members of the senior secure class have not participated in the new money and the new equity. So as we record at the end of subparagraph 2, the ad hoc group will receive around 76% of the backstop fees. We've given the court references for evidence in relation to the negotiation of the fees, both within Mr. Sousa's evidence and Mr. Reed's evidence.
Right. I'm just looking at the clock. I appreciate you may need to come back to the backstop fee and the works fees, but I'm conscious that we've got a little bit more of the document to get through, and the more complex and perhaps more central stuff is a little bit further along. So can we pick it up a little bit later in the document, perhaps?
Well, of course.
Can we look at paragraph 23 in particular? So the table above 23, which is this is I think explaining the allocation of value. If we focus on the first column, which is the low case in the plan outcome, as I understand it, that's assuming that the total enterprise value to be distributed is 1.35 billion.
My lord, that's correct.
So if you add up all, I haven't added it up, it's on a table in the bundle, but all the first column totals 899 million odd. Now, within the first line, the return for the participating creditors is said to be a total of 696 million at a rate of return of 159%. Now, that's clearly a blended rate because within that you've got 28%, 28.8% on their existing debt, plus whatever the percentage is on the new money aspect. If you take out the new money aspect within that first line, I estimate you get somewhere in the region of 570 million to take out of that. So the 570 million within that line is a return in respect of the new money. If you add to that the difference between 899 million, which is the total, and 1.35 billion, you get a further 451 million, which is return. That must be the return on the new money being provided by others, otherwise where's it coming from?
Oh, yes.
So the bottom line figure, and this is I want to see if this is correct, is that just north of $1 billion is the return being made available to, in respect of the provision of new money, which means that something like 329 million is the return on the existing debt of everybody. So the question, I think, is that right as a matter of numbers? And that's the matter I think we'll need to focus on in terms of justification.
No, that's incredibly helpful. I will check before tomorrow for obvious reasons, but it sounds right in the sense of the 300 odd being the senior secured return on their claims as senior secured creditors.
Yeah. And there's not much to add to that for everybody else.
Precisely. And then it is the combination of what is being received by everybody else in relation to both the new money, the cash payment to Samsung, and the allocation of the equity warrants, for example, in respect of which no money is being provided.
I mean, what would be useful is if somebody could do the exercise that my lord has just gone through and do it with the actual figures and set it out for us. It's breaking out paragraph 23, isn't it, effectively, and focusing on the new money.
My lord, again, I will see what we can achieve in that regard.
Because that's the, I mean, that's where this ground 2 is really all about. I mean, it's about the new money, isn't it? I mean, it's said, and I think this is even in your own skeleton, you say this is really where the focus was of the attack. The real focus of the attack is on the rewards.
We thought it was until Mr. Thornton opened the appeal orally. I have to say that's where we'd assumed it would be.
Well, I don't think he was giving up anything in his skeleton. I mean, I'll be wrong. I'll correct it if I'm wrong, but I don't think he was, and that's certainly what his skeleton seems to say.
As the court knows, our answer to that, in broad terms, is number one, it's common ground.
Yeah, you're going to have your chance to put the answer tomorrow, I know, but simply focusing on this document for the second, it's because I think of the focus on the new money that what we want really in paragraph, particularly by reference to 23, is the breaking out of the blend, or the unblending of the blend, or whatever the appropriate metaphor would be. You know, so we can see more specifically the calculation my lord's put to you, which I think relates to the new money. So I'm sorry, I don't want to. I'm not cutting you off. Obviously, you're going to have tomorrow to deal with the argument, but I'm just making sure that we have the raw material before us to understand the argument we're going to hear tomorrow morning.
Can I just try and help by seeing how far paragraph 24 goes to answering that question, or whether it doesn't provide enough? This is Mr. Johnson, the expert for the appellants. Can we look at supplemental bundle tab 15, page 539? Maybe that doesn't.
It's not immediately clear.
My Lord Justice Zacaroli's target. What this does, and the reason I showed it this week, we managed to agree this much overnight, that it's common ground that these are the returns that are earned if one looks at the one hand on the total claim in respect to the pre-existing claim and the new money that is put in. You get back an increase of between 41% and 71% on those under the terms of all returns you get in the restructuring. It doesn't separate out new money alone, which I think is probably the task.
Yeah, well, it's as I say, it's the percentage return on new money, but also the allocation of the value that is being either preserved or generated by the restructuring, which I'm taking for the low case to be 1.35 billion, between everyone in respect of their existing debt, and which I think is about 300 and something million, and the new money, which is the other billion.
My Lord, yes. And on the first point, I think my Lord right on the figure, showing that senior secured creditors are having a debt write-off of roughly 600 million as part of the plan in terms of real-world returns. Without wanting to jump around too much in the table, at paragraph 25, we've illustrated the benefits that would have accrued from the new money to Saipem and Samsung. So from doing the 25 million of new equity, they would generate on a low case an extra 80 million of value, on a high case an extra 103 million of value, because they would participate on the same terms as everyone else who's providing the equity. So that was the benefit they could have accessed if they'd chosen to do so. Then equity value. Maybe one point to make, we can go to the document tomorrow if it helps, is that the equity value has a number of assumptions within it. In other words, in order to generate both the low case and the high case, the group needs to do a number of things.
Yeah, I mean, the question of how risky the new money actually is going to be an essential point of inquiry tomorrow morning. Put it bluntly.
One dealt with by the judge, dealt with in the evidence, and not explored in cross-examination.
Well, we'll see tomorrow. But can I just shortly before 1 o'clock just see where we are? Not that I think we're hopefully in any danger of not finishing tomorrow, but just so I understand, actually Mr. Bayfield has been sitting here patiently enthralled by what's been going on around him. Does Mr. Bayfield feature in this hearing, in this debate? He hadn't featured in your division of the time previously. I don't know what you're planning for tomorrow. Obviously, Mr. Thornton needs a reply. You're going to take your course. Really just wondering whether we're going to be hearing from the ad hoc group or they're going to take that, see where they stand.
I think I'll talk to Mr. Bayfield overnight. I imagine, dependent upon the questions asked by the court tomorrow morning, to the extent I've missed anything on the clear evidence on the pricing of the money and why it was the best deal that could be achieved, Mr. Bayfield may want to deal with some of the evidence of the ad hoc group on that point in their returns. But beyond that, I can't foresee a role.
As long as, in a sense, you've agreed between you a division of time which allows for Mr. Bayfield to, subject to Mr. Thornton, to say anything he thinks that you've omitted or otherwise, or to contribute to the debate, so that everybody gets a chance to say what they want to say.
Well, of course, at the risk of time, can I make one inquiry then in relation to where I was going to go tomorrow? And the reason I was going to go there is we didn't hear any submissions about it yesterday, is the law, and in particular Virgin Active and Thames, and the importance of whether someone is out of the money when a plan is an alternative to a group-wide liquidation, and the impact on that when it comes to the fairness or otherwise of the plan.
Well, I think, do you mean, certainly speaking for myself, I think you had better deal with that. Because if you're essentially aiming at the target in paragraph 35(3) of your skeleton argument, I do think that, I mean, Virgin Active is a first instance decision and it does need revisiting in the light of Adler and Thames. I mean, I've said until I'm blue in the face, Virgin Active is not authority in this court.
Well, we of course don't dissent from that in the sense of this is the Court of Appeal. Like what we wish to explore tomorrow, if it's helpful, is that, of course, Thames and Adler are Court of Appeal authorities, but when one looks at the very different facts of Thames, an interim bridge has made clear by the Court of Appeal and made clear that things may be different when the factual backdrop is different, and in distinction to Adler, which was essentially a runoff and distribution rather than a restoration to solvency, this is a plan which does restore to solvency when a group-wide liquidation is the accepted relevant alternative. It's accepted that new money is needed, and therefore when one is looking at the benefits of the restructuring, what my submission to the court in essence will be is that if the judge was right on the findings of the new money, it being common ground the new money need is there, then one is only looking at the rump of the equity being divided around the plan creditors. If one is looking at the division of that rump, the senior secured creditors are only getting just under 16% of the equity, the 900 million of secured claims. We say the out of the money creditors are actually getting a very good deal here, and a considerably better deal than has been the case in Virgin Active, and since, admittedly at first instance, a whole series of other plans to rescue a business where the fact that someone was out of the money was seen as sufficient treatment that they didn't need to be allocated a large chunk of the benefits of the restructuring.
Speaking of myself, I think it's necessary to look again at this legal framework with the benefit of quite a bit of experience since Virgin Active was decided. And so if the question was, do you need to go to the law to put the framework in place before we look at the numbers? Speaking for myself, I think the answer is yes.
That's very helpful. And then I'll look at the numbers and then look at the judge's findings in the context of the numbers, and then deal with the horizontal fairness points, which were put very briefly yesterday, but we will respond to them.
Right, unless anybody else has anything else until, if we start at 10:30, we should be comfortable, I take it, to finish tomorrow? Yep. Yes, yep. Okay, so 10:30 tomorrow. Thank you very much.